A very warm good morning to all of you. Dear students, once again, I would like to welcome all of you to a new session of the Civics class. Today, we are continuing with the same chapter from Civics, chapter number 4, the Supreme Court, part 6. Do you remember what we were discussing in the previous class? In the previous class, we were discussing about the jurisdiction and powers of the Supreme Court. We were discussing about what is meant by jurisdiction and what were the special powers of the Supreme Court. And there we have seen there are three different kinds of jurisdiction. First one, original jurisdiction. Second one, appellate jurisdiction. And third one is advisory jurisdiction. And in the last class, we have made a detailed study about original jurisdiction. And today, we are going to discuss about the second type of jurisdiction, that is appellate jurisdiction. So, without wasting time, let's see what is meant by appellate jurisdiction. Appellate jurisdiction means the power to grant special leave to appeal against the judgment delivered by any court in the country. I repeat, appellate jurisdiction means the power to grant special leave to appeal against the judgment delivered by any court in the country. Suppose we have filed a case in the High Court, and when the High Court made or delivered the judgment, we felt like we haven't got justice properly, or in the verdict of the High Court or in the judgment of the High Court, it was not in favor of our side. In such case, if he feels that we haven't got justice, we can appeal against the judgment delivered by the High Court and we can approach the Supreme Court for justice. So, appeal means the decision made by the judgment or the High Court was not in favor of us and we feel that we haven't got justice. In such case, we can move to the Supreme Court with the appeal and we can expect that we will get justice. That is what is meant by appellate jurisdiction. It is a court of appeal, which means a court which may change the decision or reduce the sentence passed by the lower court. So, Supreme Court is being considered as the court of appeal. Suppose if a High Court or any other subordinate court made a decision or made a judgment or made a verdict, in such case, the Supreme Court can change the decision of the High Court or any other subordinate court or reduce the punishment passed by the lower court. So, that's why Supreme Court can be considered as the court of appeal, where we can appeal against the decision of the lower court or subordinate courts. Supreme Court is the final court of appeal. So, Supreme Court is the last court. Beyond Supreme Court, we don't have any other facility to approach for getting justice. Supreme Court is the last. That's why we have seen in the first part of the chapter, Supreme Court is the apex of our judiciary. An appeal to any judgment or final order of a High Court in India. So, in the case of appellate jurisdiction, even the decision made by or order or judgment made by a High Court can be appealed in the Supreme Court. This jurisdiction extends to constitutional, civil and criminal cases. So, appellate jurisdiction is dealing with all these three different situations. First one is constitutional, second one is civil cases and third one is criminal cases. So, we will discuss each one of these points, constitutional, civil and criminal cases separately. First of all, let's discuss about the constitutional cases. All matters. So, without discussing the subject or irrespective of the nature, where a certificate is issued by a High Court which involves an important point of law and needs interpretation of the Constitution can be brought before the Supreme Court. So, what is constitutional cases? Suppose if there is a case in which an interpretation or an important point of law is needed. In such cases, those all kinds of subjects can be discussed in the High Court, Supreme Court. We have already seen this particular feature. If it is related to the constitutional interpretation, that case will be coming under original jurisdiction, and but here also it is considering about the constitutional cases. All matters irrespective of the nature where a certificate is issued by a high court which involves an important point of law and needs interpretation of the constitution can be brought before the Supreme Court. So Supreme Court has got power to make interpretation. Only Supreme Court has got the power to interpret the constitution. That's why all the cases which is having an important point of law and needs interpretation of the constitution will be going to the Supreme Court. If the High Court refused to give a certificate on such a case, the Supreme Court can grant special leave of appeal. So it is not necessary that the High Court has to give a certificate or they have to give the final verdict or judgment. Then and there it can move to the Supreme Court. If the Supreme Court feels that the case or the particular issue is very sensitive, it is needed an important point of law or needs interpretation of the constitution, the Supreme Court can transfer that particular issue or case from the High Court to Supreme Court. So that's why Supreme Court can grant special leave of appeal. So these are the points related to the appellate jurisdiction, and under appellate jurisdiction the first condition, that is constitutional cases. And today we are winding up with this particular point, and in the next class we will be speaking about the remaining two concepts, that is criminal case and civil case. Still we meet in the next class. I would like to sign off. Thank you.